From the Library of Congress in Washington, D.C.
Good afternoon. I'm Carrie Johnson, the Justice Correspondent at NPR, National Public Radio here in D.C. This panel is going to discuss Magna Carta and the Eighth Amendment. And obviously, proportionality is in the news and in Congress almost all the time lately, with conversations about the death penalty, mandatory minimum sentencing, and numerous other issues. We're going to keep this short and sweet, though. And I'm first going to turn to Professor Craig Lerner, and then to Professor Vicki Jackson. We'll do a few questions and answers.
So I'm going first, and I have doubts about the very premise of this panel, I suppose. As we approach the 800th anniversary of the Magna Carta, I suggest that we gird ourselves for all manner of unrealistic and anachronistic claims about the document. Those who attended the morning panel heard that the claim that the Magna Carta enshrines a jury trial right is problematic for, among other reasons. The word jury never appears in the Magna Carta, and it would be difficult to enshrine a jury trial right since jury trials didn't exist in 1215 in any criminal cases and hardly any civil cases. That's a little problematic claim. Recently, American scholars and judges have claimed that the Magna Carta embodies the proportionality principle, mandating that the punishment must fit the crime. And the claim is politically relevant because the claim is that that proportionality principle then made its way into the English Bill of Rights of 1689, which was then reproduced almost verbatim in the Eighth Amendment of the US Constitution, which prohibits cruel and unusual punishment. Well, the plain text does not suggest a proportionality principle, but supposedly the plain text is infused with the proportionality principle dating back 800 years or then 600 years to the Magna Carta. So I question this narrative, and I'm going to do so very briefly, I know, because we have time constraints. So I have three pieces of evidence: text, contemporaneous legal documents, and the political and moral culture of 13th century England, if you will. So I'll make this brief, but this is different from the previous panel. We're going to be going to the Magna Carta here. So I'm not a legal historian, so I just picked up the text of the Magna Carta, and it's really fascinating. It really is. In many respects, it's actually more interesting than the US Constitution, I have to say. It's all sorts of very interesting things in it. And the chapters that are said to embody this proportionality principle are these chapters 20 to 22. And those chapters regulate a penalty called amercement. You might wonder, what is an amercement? I wondered, what's an amercement? So within the text, it's quite interesting. The chapter 20 says that there shall be no amercements except those that are in accordance with the offense and that leave the offender in possession of his contentment or livelihood. So the first limiting principle, in accordance with the offense, is certainly evocative of the proportionality principle, hence the claim the Magna Carta embodies the proportionality principle. But let's think about this a bit. So you have two limiting principles, right? And they're not identical, and they can be harmonized in some cases, but not all. So if it's a minor offense, the proportionate penalty could indeed leave one with one's contentment. But if we're talking about a murderer or a rapist, you would never say, let's punish him, but leave him or her with his or her contentment intact. That would be bizarre, wouldn't it? And so that made me think, well, amercement is not about a penalty for a criminal punishment or a crime or a serious crime for sure. And indeed, if you look at the text, chapter 20 refers to delicto, which is a tame word which can be translated as offense. Other chapters in the Magna Carta deal with crimen or crimes or felonia or felonies. None of those chapters suggest a proportionality principle, and none of those chapters mention amercement. Now, chapter 32, for example, suggests that any convicted felon face the forfeiture of all of his land. So that made me think, how could a convicted felon be left with his contentment intact, consistent with chapter 20, but nonetheless be deprived of all of his land? Well, that made me think, clearly, amercement was not understood to be a punishment for a felony. Well, then you look at the contemporaneous legal text, and you don't have to, but I'll assure you that I did, and they're Glanville, Bracton, the Pipe Rolls, and in all of these documents, immersement is never suggested to be a criminal punishment. What is immersement? Well, immersement would be, for example, if you abuse the judicial process in some way, if you filed a false claim, or if you filed a lawsuit and then didn't prosecute it zealously. It's sort of the equivalent to what lawyers might today call a Rule 11 sanction. Or if, for example, you came upon a dead body and didn't report it to the coroner, or if you didn't raise the hue and cry promptly enough. So these were the sort of things that will result in immersement. And none of them really are criminal offenses. And that was the judgment of the great legal historian James Fitzjames Stephen, who said that immersement was, quote, far remote from criminal offenses. And finally, I just want to think about the world of 13th century England. So the past is said to be a foreign country, and I would say 13th century England is a very foreign country. The criminal justice system, such as it existed, was the work of amateurs and was perilously ineffective. Crime rates, violent crime rates, were astronomically high. One estimate for the homicide rate in London in 1340 was 100 per 100,000 inhabitants. That's roughly 100 times what it is today. So in effect, and by the way, for those rare defendants who were caught and convicted, the litany of gruesome punishments was long, not simply execution, but also castration, blinding. I exhumed a horrible, gruesome case about a fellow in 1217, almost an exact contemporary of the Magna Carta, who was convicted of theft, larceny, and was castrated and blinded after a trial by battle. So that's 13th century England, okay? And in fact, faced with very high rates of violent crime, my suggestion as someone who's more of a law and economics scholar is that 13th century Englishmen adopted a deterrent strategy that consisted of very public and very cruel punishment. Now this is highly objectionable to us, and I think it is highly objectionable, period, but there's no evidence that 13th century Englishmen shared the identical moral allergies that we do to cruelty. So does the Magna Carta finally have anything to say about the proportionate punishment for a fellow named Craig Jackson, who was convicted at age 17 of participating in an armed robbery that resulted in the death of a store clerk? These were the facts of a recent Eighth Amendment case that resulted in the overturning of a life without parole sentence. And I think the obtuse starting point would be that the authors of the Magna Carta thought that death or worse were totally proportionate punishments for robbery and murder. So the modern scholar and judge required to adopt a somewhat more sophisticated argument that the Magna Carta embodies a proportionality principle, mandating that the punishment must be in proportion to current attitudes towards the severity of a crime. And the very thin reed upon which this argument is piled is this in accordance with the gravity of the offense language from Chapter 20. And I just do not think that any fair reading of the Magna Carta supports this very ponderous argument piled atop it. So in concluding, the Magna Carta, of course, embodies a proportionality principle in a trivial sense that could be ascribed to every legal code, but as one tries to extract more specific lessons, chapters 20 to 22 are of no legal relevance to us. So I'll state this very emphatically, just to create an argument.
Thank you, thank you. And
because,
Professor,
let me just, I almost said, because they are not addressed to the question of criminal punishment. The Magna Carta's role today is not in interpreting the law or in explicating it, but in mythologizing it and giving it a transcendence that maybe all human law requires to achieve legitimacy. That's it.
Thank you. Professor Vicki Jackson, Professor Lerner has left us in 13th century England and mentioned that relatively recent Supreme Court decisions on juveniles and life without parole have incorporated portions of the Magna Carta, in his view, incorrectly. What about this as a living document?
So let me take that up without agreeing to the historical characterization of my colleague, except I'm going to read one thing.
Please.
I'm going to read you from the translation of the 1215 Magna Carta, Chapter 20, that is in this wonderful book that Professor Howard prepared based on the most authoritative English translation in the British Museum of the 1215 document. Quote, "A free man shall be amerced," which is some sort of a fine, I think we're agreed, "for a small fault only according to the measure thereof, and for a great crime according to its magnitude." It then continues. Professor Lerner may be correct that this applied only to amercements and not to the bloody bodily penalties. But it's not open to debate that the principle of these amercement clauses was one of proportionality in the levy of penalties. Now, coming to the question I was asked, the legal documents that have impact and influence in the world do not have that impact because of their details. This regulates, the Magna Carta regulated fish weirs. I don't even know what they are, but I'm imagining this is a detail. The big impact of Magna Carta was on the idea that government needed to be limited, and for our purposes, that punishments, penalties, needed to be limited. Whether they understood the application of this principle to the full range of punishments is not the most important question for us. The most important question for us is now that the US Supreme Court has persistently said, really since the late 19th century, that the Eighth Amendment demands some degree of proportionality between the offense and the punishment. How should that be applied in the issues going forward for us? As I was asked to do in recent cases, Eighth Amendment issues have come up in three major areas. One involving the death penalty, in which the court has found that certain offenses, for example, rape without homicide, awful as they may be, simply are not severe enough to warrant the death penalty for anyone. Or certain categories of offenders, people under the age of 18 who may commit horrific crimes, cannot be subject to the death penalty for their horrific crimes because of their age. Second, a set of cases challenging recidivist statutes. This is like the California 3 strikes you're outlaw, and those have been largely upheld, with one exception in recent years where the recidivism law provided for life without possibility of parole. That was in a case called Solomon-Helm, and the court said that's not good. But otherwise, recidivism laws with very, very long sentences for people who've written a bad check for $120 or stolen some golf clubs have been upheld. Third, and these are the most recent cases, are the sentencing of juvenile offenders to life without parole sentences. And there were two recent important cases. The first of them was a 6-3 decision by the court in Graham against Florida in 2010, where the court held that juveniles, persons under the age of 18, at the time of a non-homicide offense, cannot be sentenced to life without parole. Chief Justice Roberts agreed with the result, but not the categorical reasoning. For Chief Justice Roberts, it was the particular facts of the particular child's case that made the sentence disproportionate for that child. As Chief Justice Roberts pointed out, not even the prosecutor had sought the sentence to life without parole that the trial judge had imposed. In 2012, the most recent case that I've briefed for this, Miller against Alabama, 5-4, the court held categorically that juveniles convicted of homicide, the most serious offense, cannot face a mandatory life without parole sentence. The gist of this holding is that the trial judge has to be able to consider whether the particular juvenile is so incorrigible, so awful, that we can decide now, before the child is 18, that they can never be eligible for parole, or whether the trial judge has to individualize that consideration, like the death penalty cases for adults have required. Now, let me try to put this in a comparative perspective for you just briefly, if I have time. The Magna Carta's principles of limited government have been of enormous influence in the world, and they were of influence in our Constitution in a large-scale way. A very unique and important contribution of the US Constitution, the big idea that has had great influence in the world, is judicial review. The idea that limits on government must be must be enforced by independent courts. And the principle of proportionality is now widely used by other constitutional systems in other democracies to enforce not only proportionality limits on punishment, but proportionality in other areas in which the government affects us. Let me just mention a couple dealing with punishment. In Germany in the 1970s, and more recently in a court called the European Court of Human Rights, which makes legal decisions that are binding to, I think, 45 or 47 member states. They have held that even for adults engaged in horrific criminal conduct, life without any possibility of being considered for release is disproportionate, because it ignores aspects of human dignity, it ignores the possibility that a person will change. This is very far from where the US is at the moment. In Canada, interpreting language in its charter drawn from the same British English sources that our Eighth Amendment is drawn from, has held, and their doctrine says we only review for gross disproportionality, same thing as the US Supreme Court says. However, that court struck down a statute providing for a 7-year minimum sentence for importing narcotics. Why? Because not every importation of narcotics, and I think marijuana may have been included in the scheme, but I'm not sure. Not every importation is so serious as to warrant that mandatory minimum. If you think about the role of mandatory minimums in the United States and the degree to which our adult population is incarcerated, and is incarcerated in ways that fall disproportionately on minority group members, we might have something to learn from these other approaches.
I'm afraid we're going to have to leave it there, although I wanted to note that while I was sitting here, someone tweeted to me that Senator John Cornyn, a Republican from Texas, is now talking in the Senate about a mandatory minimum sentencing bill he's got going. So this conversation is going to continue into 2015. Thank you very much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.